Number one important thing is, what is the service sector that you are drafting the employment contract for? Okay. I have seen when we had done the last class, okay, I was discussing that, is there somebody who's working in a factory? Is there somebody who's working in a bank? Do we have somebody from the IT sector, right? So which is the sector that you are drafting for? Okay. Why would it be different, guys? If I am hiring somebody from the IT sector, the skills that I want, the service that I want from that person would necessarily be different from what I would want from an accountant, correct? And would per se be different from what I would want from a supervisor, okay? So the sector also depends. If I am in a manufacturing sector, what is the role and responsibility of the factory manager? Will it be regulated by a separate act, correct? Is it the same for IT employees? Is it the same for banking institutions? Correct. So you need to first ensure which is the sector that you are hiring for. Okay. Why do we consider this? Because when you lay down the terms and conditions of employment, it would vary as per the sector. This we have also seen while we have done the shops and establishments, or while we were dealing with the first lecture, that if you are in a different sector, the applicability of the acts that are there for you would be different as well. So you need to identify that, adhere to the relevant statutes that are there in place for your sector as well. Okay. Then once you have recognized that, very important, what is the seniority of the person you are drafting the employment agreement for? Okay. Are you going to have the same set of requirements that you are going to have for a supervisor, a CXO, or just a blue collar worker? Are you going to have the same set of requirements for a CXO, for an accountant, or for a blue collar worker? No, right?
No.
The clauses that you impose on different people, you would want to retain higher level of employment, right? You want to retain people at the top level for a maximum period of time, because it is very difficult to acquire talent at that stage. Okay. The work that is done at lower level, okay, it's replaceable very easily. If you see, the job of a blue collar worker is replaceable very easily. So is it going to harm your organization that much that if the blue collar worker leaves, is it going to cause pain to you to replace that worker? Not as much. But if a CXO level person or a top level management person leaves, what is the time that you're going to require to replace that person? Correct. So talent acquisition, as the seniority rises, the difficulty also rises. Correct. So you need to ensure the clauses that you put for a senior level management would be very strict in nature. However, if there is a lower level person or a supervisor category or a blue collar, you are rather flexible. Okay. How is this to be considered? The amount of effort and the amount of money and training the company would require to replace that person, right? So in that manner, you change the strictness and leniency of the clauses while you draft. Okay. Very important again, what is the kind of agreement you are drafting? When a person is on retainership, okay, like I am a lawyer, I'll give you my example. I could actually do compliance work for HR at different companies, okay? So they can put me on a retainer, which is hire my services for a fixed period of time, and they will pay me a fixed retainership fee, okay? I am not their employee, I am a third party for them, and they are a company which may or may not have a legal need. It can be that in a month they have received 5 notices. It can be that for 3 months they don't receive anything. For that purpose, looking at the frequency of legal actions that come to them, they have hired a lawyer on board so that every time something comes, they don't need to approach anybody. For this, they give a fixed monthly fee to me, irrespective of the work that I do. Okay, so I am on retainer for them. This is one example. Consultancy is when I am independently consulting for another company, not on their muster. Okay, I am not an employee of the company. I am independent party. Okay, so I do not find my name on the muster. Okay, this is also third party transaction outside of what the company wants. This can be also for cases when you do not want to hire a lot of people for that area of expertise. Hire consultants, and as and when need arises, this can be hour basis. So you need the consultant to dedicate a few hours to you. It can be for project basis also. happens a lot of times when you hire a consultant because there is an ongoing project and you need that person's expertise, let's say for a period of 6 months or 3 years, it could be anything, and then that term ends on project basis. Full-time employment is where you actually, there is an employment contract, you hire the employee on board, you're following everything that is there, a statutory requirement that is there, and the entitlements of an employee are given to them. Here, if you see, consultants have a more flexible way to work with the companies because they will not be strictly bound by the policies that are there to you. However, if there are employees, they definitely need to follow the leave policies, the social media conduct, the dating policy. I'm not saying that consultants will not have it, but employees will have it in a more stricter manner because they are representatives of the company. Okay, so you need to decide the kind of person you are going to hire. Basis that, you either would enter into these kind of agreements. Okay, so while you hire people, it's not only that you would be doing an employment agreement, having that person on board by doing an appointment letter followed by an employment agreement or just an appointment letter. It could be a different type of agreement altogether depending on the need of the company. Okay, this is where the concept of contract of service and contract for service comes into picture. Okay, I have an article which I want to refer. It's an IP Leaders article only. Very nicely, there is a table, which is laid down, and I'll just share the link with you all also. It's an IP Leaders article only. It's very simply laying down what is the difference between a contract of service and contract for service. This is very important for you all to know while you are, in the hiring part of the structure. Okay, so if you see, what is contract for service? Okay, so the parties, a contract for service is an agreement that is entered into by a company with a third party. I have engaged Mr. Anup Thomas for XYZ services. This is how you can remember it to make it easy. I have engaged XYZ person for that service. Okay, so when I say contract for service, I am having a third party on board to give me certain services that I would need. This person is not going to be my employee. Okay, so this is a contract for hire of consultancy services, for hire of legal services, for hire of software development services, for hire of data management services. It could be anything. So this is known as contract for service when you are having a third party on board. Okay, this third party is an independent service provider. Okay, this is not an employee of the company. Okay, very important. When you do a contract for service, the third party is not entitled to the benefits that our employees are entitled to. Okay, so let's say all the employees of the company are getting a Diwali bonus, sending out a gift. You don't do this for third parties, right? You're doing it for the employees of the company because their hard work is ultimately making the company grow and having a goodwill and all of that, right? So third party people do not have right. Contract for service hua, so you don't need to give the entitlements to them. Okay, company also does not have control over the third party because they are independent, right? Doing just providing the services that you are asking them for. So the company would not have an entitlement on that person. Okay, this is in contract for service. Okay, what is the ownership of intellectual property? Let's say you have a third party on board and they've developed, let's say, an article or a chapter or a book, if this is an educational institution. So company will want the service provider to assign ownership of IP rights and return, they can pay. Okay, this arrangement may or may not happen. If there are consultants on board, they are generating something during the ongoing project. I have hired, let's say Himanshi, I've hired you on board. Okay, and you are with me for a period of 6 months and we are doing a research on, let's say, capital punishment. Okay, this is a very hypothetical situation. You generate something which is an interpretation, this comes to be published. I would say that, Himanshi, this has happened because you were doing my project. This is not something that you have independently generated. Because you were in my contract and you have generated this, that's why I would just pay you for the work. I would keep the IP rights to it. But when you enter into consultancy contracts, the consultant may say that, I'm not going to give IP rights to you. And this is also part of negotiation. It can happen that Himanshi says that I have been involved in doing so and so. I have certain copyrights in my name. and I would have done this irrespective of your project or not. So I'm not going to give my IP rights to you. So this also is a part of negotiation. How does IP work in this? Consultants के साथ negotiations may happen through this. Okay. Now, what is a contract of service? Okay. So here it is an agreement that is entered into by the company with an individual for availing his or her services. Basically, you are employing somebody on board. You are not hiring them for services. You are taking their service immediately in the employment. It is known as contract of service. Okay. Here, the individual is employee of the company. You are entitled to the benefits that the company would give you. Company has control. Of course, the company has control over the employees, and the employees are bound to obey whatever the company says, the policies, the contract, everything. Okay. Of course, if an employee is generating any IP, it could be an invention, it could be a copyright, it could be anything. It is the right of the company to have it. There is a very strict intellectual property clauses that are there. So a quick description, differentiation is also given in the chart, that a contract for service is basically a company and a third party. For word अगर आप याद रखेंगे तो आपको याद हो जाएगा. I have engaged this person for something. Okay, just remember this line so you will never get confused in this concept. For doing this work, I have engaged this person. तो आपका third party आ जाता है. Of मतलब employee. Of course, this for service में the person is an independent contractor, and of में it is an employee-employee relationship. Third party, the company does not have control. In contract of service, the company has control. And IP, you can pay and get the IP. Here, the company is by default the owner. Okay. So this is the difference you should be knowing because you're at the hiring stage.